Good afternoon. Thank you for joining us for today's webinar on state law developments in cybersecurity and data privacy. This is a dynamic area of the law, and we appreciate this opportunity to discuss the developments that have shaped the current data privacy and cybersecurity landscape, and the trends that will guide future legislation. My name is Marcus Christian. I'm a partner in Mayor Brown's cybersecurity and data privacy practice based in our Washington, D.C. office. In my professional life, I have dealt with issues of cybersecurity and data privacy for more than 20 years in various organizations. I am truly fortunate to have a wealth of capable and collegial colleagues at Mayor Brown, and am joined by two gifted attorneys today. First, I'm delighted to introduce Shen. Lay is a partner in our cybersecurity and data privacy and technology transactions practices and based in our Chicago office. As you can see from the slide, Lay is very skilled and experienced as a practitioner. But what the slide does not capture, however, is her passion for privacy. Lay truly relishes opportunities to learn about privacy developments and to share her knowledge with others. I certainly look forward to hearing from Lay today. I'm also pleased to introduce Joshua Silverstein. Josh is a senior associate in our cybersecurity and data privacy and national security practices. During his time at Mayor Brown, Josh has advised clients on a wide variety of cutting-edge issues. He has deep experience in enterprise, automotive, and product cybersecurity, to name a few areas. And when we are dealing with complex cybersecurity incidents, Josh is a go-to associate. Lay, Josh, thank you for presenting with me today. Now that I have introduced the Mayor Brown team, it is time to turn to the substance of this webinar. Josh, would you please set out the roadmap for today's discussion?
Thanks, Marcus, for that kind introduction. Now, I'd like to provide an overview of our presentation and what we intend to walk through today. First, we will provide some background on how we got here and the foundations for regulating cybersecurity and data privacy at the state level that have developed over the past several years. Then, we will sequentially consider consumer data privacy laws, other privacy laws and frameworks, cybersecurity law and regulation, and recent federal responses to privacy issues raised by the COVID-19 pandemic. Now, digging into this agenda, after we provide some contextual background, we will turn our focus onto recent developments in consumer data privacy laws. Most notably, that means discussing the hot-off-the-presses CCPA final regulations and the California Privacy Rights Act, or CPRA. Under this heading, we will also explore developments in CCPA copy and multiple federal attempts to develop a consumer privacy framework in response to what is happening at the state level. We will then turn to other key privacy laws and frameworks, including biometric data handling laws, data broker laws, and the recent development by NIST of a privacy framework. Now then, we're going to turn to discuss recent developments in cybersecurity law and regulation at the state level. Since all 50 states have passed data breach notification laws, state activity in this space to include more prescriptive and detailed requirements, most notably including the passage of the New York SHIELD Act and similar laws prescribing specific data security expectations. In addition, we will also discuss Internet of Things laws and Ohio's relatively unique data protection law. Finally, we will discuss the possibility of federal legislation to manage the significant privacy issues raised by contact tracing, or the usage of medical and geolocation data to facilitate management of the COVID-19 pandemic. Now with that, I'm going to turn it over to Lay to set the scene.
Thanks for teeing things up, Josh. Before we consider some of the more recent developments in cybersecurity and data privacy that you mentioned, it's useful to consider how we got here and what foundation already exists for regulating these issues at the state level. Unlike the EU and its General Data Protection Regulation, or the GDPR, the United States does not have an overarching data protection law. Rather, we have a patchwork of laws that are largely sectoral or based on the types of data a business collects or the activities that a business conducts. So for example, if you're a financial institution, then you're subject to the GLBA. If you're a healthcare entity, then you're subject to HIPAA. If you collect information from children online, then you're subject to COPPA. And if you collect certain types of sensitive personal data, then you're subject to certain data breach and data security laws. So that's why most of the laws we'll be discussing today tend to be more narrowly focused. And while some of the data protection laws are federal, the majority of these laws are state-driven, which has the potential to lead to conflicting requirements. But this structure is slowly starting to change now after the passage of the CCPA. The CCPA is a sweeping new data privacy law that became effective earlier this year in January. It is considered to be sweeping because it is very different from the traditional U.S. data privacy laws that I discussed earlier. Rather than focusing on data breach notification requirements or security requirements, the CCPA provides consumers with certain rights to their personal data. These rights include the right to know, the right to opt out of sale of personal information, the right to delete certain personal information, and the right to not be discriminated against for exercising these rights. In connection with these rights, the CCPA also imposes a number of obligations on businesses, which I won't go into detail here, but you can learn about on our earlier three-part series on the CCPA. The CCPA had initially been drafted so broadly that it also covered employment-related and business-to-business information, but amendments passed late last year exempt this information from the majority of the CCPA requirements. However, these amendments are scheduled to sunset at the end of this year. A few days ago, on June 1st, the California Attorney General submitted its final proposed CCPA regulations to the California Office of Administrative Law, or OAL. There were no changes between the prior version of the regulations that were released in March and the final version of the regulations. The OAL now has until September 13th, which is 30 working days, plus an additional 60 calendar days due to the governor's COVID-19 related extension, to review the regulations and determine whether they satisfy the requisite procedural and substantive requirements. Assuming the OAL has approved the regulations, they will be filed with the Secretary of State. Under normal rules, if the regulations are filed by August 31st, they would become effective and therefore enforceable on October 1st. And if they are filed after August 31st, they would become effective on January 1st, 2021. However, the Attorney General's Office has requested that the OAL both expedite its review of the regulations and also that it find good cause for the regulations to become effective immediately upon filing. The OAL has the power to grant both requests, but it is unclear if it will do so, particularly since over 50 other proposed regulations from various other state agencies are also awaiting the OAL's review. The CCPA indicates that enforcement of the CCPA is not to begin until 6 months after publication of the final regulations, or July 1st, 2020, whichever is sooner. Due to the delay in issuing the final CCPA regulations and difficulties and disruptions brought about by COVID-19, numerous industry groups had asked the Attorney General's Office to postpone enforcement of the regulations until March 20th, 2021. The Attorney General's Office denied the request, though. Specifically, it explained in its final statement of reasons that to the extent the regulations require incremental compliance, the OAG may exercise prosecutorial discretion if warranted, depending on the particular facts at issue. Prosecutorial discretion permits the OAG to choose which entities to prosecute, whether to prosecute, and when to prosecute. The AG also separately indicated in another statement that they are committed to enforcing the CCPA starting July 1st. While the regulations will not be enforceable for at least a few more weeks and possibly for months thereafter, keep in mind that violations of the CCPA statute itself will be subject to enforcement by the California Attorney General starting July 1st, 2020. Now that we have the final regulations, businesses should become familiar with the requirements, as the regulations clarify and in some cases expand upon a number of the obligations in the CCPA. For example, the regulations describe what needs to be included in the notice at collection and provides clarifications regarding notice requirements for businesses collecting employment-related information. It also identifies what needs to be included in the privacy policy, requirements and timeframes in responding to consumer requests, how to calculate the value of consumer data, among other requirements. In connection with the final regulations, the Attorney General's Office also issued its final statement of reasons. This document provides some helpful insights into the Attorney General's views on certain issues and why it did or did not make certain changes to the regulations. While businesses work to comply with the final regulations, though, waiting in the wings is the California Privacy Rights Act, or the CPRA, which is a new proposal from Alistair McTaggart, who was the drafter of the 2018 ballot initiative that formed the basis of the CCPA. The CPRA would amend the CCPA to create new privacy rights and obligations in California. For example, the CPRA would establish a new category of sensitive personal information and give consumers certain new rights regarding the use of such sensitive personal information. Sensitive personal information would be defined to include information traditionally covered by state data breach notification laws, such as social security number, driver's license number, passport number, and financial account information. But it also includes other types of personal information, such as precise geolocation, race, ethnicity, religion, union membership, personal communications, genetic data, biometric or health information, and information about a person's sex life or sexual orientation. The CPRA would also grant California consumers the right to request the correction of their personal information that's held by a business if that information is inaccurate, which is currently not a right under the CCPA, but is a right under the GDPR. The CPRA also specifically addresses requirements regarding the use of cross-context behavioral advertising. The CPRA would also establish the California Privacy Protection Agency to enforce the law. The CCPA, by contrast, is currently enforceable by the California Attorney General. Because the CPRA is being proposed as a ballot initiative, it needs over 685,000 verified signatures in order to qualify for the November ballot. In May, over 930,000 signatures were submitted. So between now and June 25th, each county in California will need to determine if enough of the collected signatures were in fact valid, and then the Secretary of State will tabulate the verified signatures to determine whether the measure qualifies for the November ballot. If so, the CPRA will be on the ballot in November, where a number of polls have indicated that it is likely to pass. But of course, we have an unexpected twist here. A couple of days ago, on Monday, June 8th, McTaggart actually sued the Secretary of State's office regarding the timing of the signature verification process. Specifically, the complaint alleges that the Secretary of State delayed notifying counties to begin counting signatures, which in turn might make the CPRA miss the deadline to qualify for the November ballot. Counties typically have 30 working days to verify the signatures after being notified by the Secretary of State. And since the Secretary of State notified the counties on May 14th instead of May 13th, which is when the signatures were submitted, this means that counties actually have until June 26th to complete their verification process. This is 1 day past the deadline for qualification for the November ballot. So if the counties did, in fact, take their full allotted time to verify, then the CPRA would actually not qualify for the November ballot. The complaint requests that the court require counties to complete their review by June 25th, thus cutting off their statutory period of review by 1 day. So this is another development in this area to watch. So assuming the CPRA qualifies for the November ballot and is approved by voters, the CPRA would become effective on the 5th day after the Secretary of State files a statement of an approving vote, which would be sometime in early December 2020. but it would not become operative until January 1st, 2023. In California, a delay between a statute's effective and operative dates is meant to permit businesses to come into compliance and government agencies to build out enforcement mechanisms. In the interim, the CCPA would remain operative and enforceable, though it is unclear to what extent the Attorney General would prosecute any CCPA violations. And finally, one of the anticipated benefits of the CPRA is the extension of the expiration of the employee and business-to-business exemptions under the CCPA from the end of this year to January 1st, 2023, which would allow time to address the employee and B2B privacy questions in a separate bill. However, if the CPRA does not pass in November, there are currently no bills being proposed to extend these exemptions under the CCPA. In addition, the California legislature would not be in session in November or December, meaning a special session would be needed to address any possible extensions. Otherwise, the exemptions would sunset at the end of the year, and employee and B2B data would be subject to all of the requirements of the CCPA starting in 2021. Now, if the CCPA and the CPRA were not enough for businesses to grapple with, after the passage of the CCPA, a number of other states have also proposed their own consumer data privacy laws. Some of these proposed laws are very similar to the CCPA, but a number are quite different, with one even being modeled after the GDPR rather than the CCPA. This, of course, leads to the potential for conflicts among the various state consumer privacy laws. The good news is, while many laws have been proposed, most have not yet passed. However, given the number of copycat laws that have been proposed, this reflects a growing interest in regulating data collection usage at the state level, and it's likely a matter of time before similar laws are indeed passed. One law that did pass in 2019 was Nevada's consumer privacy law. However, the law is much narrower in scope than the CCPA or the other CCPA copycat laws. While the CCPA provides a general right for consumers to opt out of the sale of their personal information, the Nevada law only provides consumers with a right to opt out of certain sales of their personal information. Specifically, consumers may opt out of a sale of their personal data to data brokers or other entities that intend to further license or sell the information. No other states so far have passed a law that provides the same rights or obligations as the CCPA. To address the concern that we might end up with 50 different state consumer privacy laws, all with different or conflicting obligations, Congress has taken up multiple bills aimed at addressing these consumer privacy rights nationwide. The most recent such bill is the Consumer Data Privacy and Security Act, which was introduced in March of this year. Other bills introduced include the Consumer Online Privacy Rights Act and the Consumer Data Privacy Act. None of these have passed yet, so we'll need to wait to see whether we'll end up with one federal consumer privacy law that preempts the state laws, or whether we'll end up with a patchwork of consumer privacy laws similar to our data breach notification laws. And now I'll turn to Marcus to continue our discussion on more focused data privacy regulatory developments.
Thanks, Leigh. Another trend at the state level has been the passage of laws restricting the use of biometric data, such as fingerprints, facial scans, and iris scans. 3 states, Illinois, Texas, and Washington, have enacted statutes that impose restrictions related to biometric data. In 2008, Illinois started the trend of state regulation of biometric data by enacting the Biometric Information Privacy Act. People commonly call the law BIPA. BIPA contains a number of requirements for certain companies that collect, use, or store biometric identifiers. Among other obligations, BIPA requires private organizations that possess biometric data to obtain informed written consent and to give written notice before they collect, store, or use this type of data. The Act also prohibits companies from selling biometric information, and it mandates that they establish a written policy that communicates the guidelines for retaining and destroying this information. Texas was the second state to enact a biometric privacy law in 2009, and it was followed by Washington, which passed its own law in 2017. Like Illinois, Texas and Washington limit the use and storage of biometric data. However, there are differences. For example, Washington allows companies to sell, lease, or disclose biometric data for a commercial purpose under certain circumstances. In addition, neither Texas nor Washington created private rights of action for violations of their laws. Illinois did, and since 2008, plaintiffs have filed numerous class action lawsuits under the Illinois law. Since Illinois enacted BIPA, other states have considered general biometric privacy laws, but only Texas and Washington have passed such a law. However, other states have incorporated provisions addressing biometric data into more generalized cybersecurity and privacy laws. For example, many states have amended their data breach notification laws to include biometric data within the definition of personal information. In addition, both the CCPA and the New York SHIELD Act include biometric data within their scope. As the use of biometric data continues to grow, companies will want to follow state law developments closely as they relate to the collection, storage, and use of this data. Another privacy trend is the passage of laws that specifically regulate the activities of data brokers. Now, what is a data broker? The laws generally define data brokers as businesses that, 1, collect the personal information of one or more state residents with whom the data broker has no direct relationship, and 2, sells or licenses that information to third parties. In May of 2018, Vermont became the first state to enact legislation regulating such personal information data brokers. Since 2019, the Vermont law has required data brokers to register with the state, implement a comprehensive information security program, and notify the authorities of security breaches. The law also defines brokered personal information fairly broadly. Not only does the definition include information such as social security numbers, it also includes date of birth and place of birth, mother's maiden name, and the name or address of a person's immediate family member. As some of you may note, many of these information elements go well beyond the scope of most data breach notification laws. Vermont is not the only state with a data broker law. In October of 2019, as companies were preparing for the CCPA, California enacted its own data broker law. That law became effective on January 1st of this year, and the California Attorney General issued an advisory on January 6th reminding data brokers of their obligation to register with the California AG before the end of January. Definitions of the data broker law's key terms, including business, consumer, personal information, sell, and third party, use the corresponding definitions from the CCPA. California's data broker law specifically excludes consumer reporting agencies regulated by the Fair Credit Reporting Act, financial institutions regulated by the Gramm-Leach-Bliley Act, and entities regulated by the Insurance Information and Privacy Protection Act. Unlike Vermont's law, the California law does not mandate data security program requirements. One key issue under any data broker law is whether a company has a direct relationship with a customer. After all, if an entity has a direct relationship with a customer, it is not a data broker. The Vermont Attorney General has provided guidance on the meaning of the direct relationship. The Vermont AG's guidance provides that a direct relationship exists if a customer is 1, a customer, client, subscriber, user, or registered user of the business's goods or services, 2, an employee, contractor, or agent of the business, 3, an investor in the business, or 4, a donor to the business. Vermont brought its first enforcement action under this law approximately 3 months ago. On March 10th of 2020, the Vermont Attorney General initiated its first enforcement action under the data broker law against Clearview AI Incorporated. Vermont alleges that the company violated the data broker law by fraudulently acquiring brokered personal information through the use of its screen scraping technology. The complaint alleges that Clearview AI used screen scraping to amass a database of 3 billion photographs, which it then combined with facial recognition technology to create a commercial service that allows a customer to upload a photograph and instantly identify the individual through facial recognition matching. Although Clearview claims that the technology exists to help law enforcement, the complaint alleges that Clearview has also provided its app to for-profit organizations, investors, and foreign governments. Clearview only registered as a Vermont data broker in January of 2020, shortly before the publication of a New York Times article discussing many of the issues outlined in the Vermont complaint. In addition to the data broker law violations that were alleged, the complaint also alleges violations of the Vermont Consumer Protection Act. The state requests injunctive relief, restitution, disgorgement of Clearview's profits, and civil penalties of $10,000 for each violation of the Consumer Protection Act and of the data broker law. Now I will pass the microphone to Josh, who will close out the discussion of data privacy.
Thank you, Marcus. In addition to the potentially prescriptive guidance that Marcus and Lay laid out above, the National Institute of Standards and Technology, which published the highly popular Cybersecurity Framework, put out a companion privacy framework in January 2020. The framework recognizes that although a well-run cybersecurity risk management program will protect against some privacy risks, cybersecurity alone just isn't sufficient, as privacy risks can arise by means totally unrelated to a cyber incident. As NIST has explained, this privacy framework is a voluntary tool, and it's intended to help organizations, quote, identify and manage privacy risks, build innovative products and services while protecting individuals' privacy. Now, the privacy framework is consciously modeled on the cybersecurity framework, incorporating a similar structure of core, profiles, and implementation tiers. Thus, if you are familiar with the cybersecurity framework, the basic structure of the privacy framework will also be familiar to you. Moreover, NIST specifically envisions that organizations will use both frameworks together to address privacy and cybersecurity risks. Now, ultimately, this framework is intended to help organizations answer what NIST identifies as the fundamental question from a privacy perspective, and that is, how are we considering the privacy impacts to individuals as we develop our systems, products, and services? With that, we can shift our focus to primarily cybersecurity issues, including and beginning with the one with which many of us are probably most familiar from addressing cyber incidents at our own organizations or with our clients, and that is data breach notification. Now, data breach notification laws are the first item on this agenda for cybersecurity because they really do bridge the gap between privacy and security. First, all 50 U.S. states have enacted data breach notification laws. These laws require businesses to notify individuals and/or state regulators of qualifying cyber incidents. As you can see, South Dakota and Alabama became the last outlier states to enact such laws in 2018. But many states have continued to revise and expand their laws in the intervening years. Although the patchwork nature of these laws has been one of the primary instigators behind the thus far unsuccessful push for federal data breach notification legislation, there are certain common features across many, if not all, of these laws, including required notice to consumers under the state, delayed notice obligations for law enforcement or remediation purposes, and exceptions from notice for encrypted data. Certain trends have also emerged in how these laws are continuing to evolve. First, states are generally using broader definitions of personal information in amended statutes. For example, Arkansas amended its data breach notification law last year to add biometric data, including face prints and retinal scans, to its definition of personal information, the breach of which would trigger a notice obligation. Now, you may recall Marcus discussed the biometric data aspect of this trend earlier, but other data elements are also being added as well, including things such as online account information. Second, states are more frequently setting specific time limits within which notification must occur. Now, many laws do still tend not to specify specific notification timeframes, but instead require notification within a reasonable time period, such as, and I quote, as soon as possible and without unreasonable delay. However, several amended laws, by contrast, have established specific notification timeframes. For example, last year, Maine passed an amendment to its data breach notification law requiring notice of a breach within 30 days, when previously there had been no set time frame. Finally, many states now require notification of the state attorney general or other regulatory body. Now, we expect all of these trends to continue, including the expansion of protection for consumers and the expansion of obligations for businesses. Now, as I alluded to at the outset, one of the most prominent recent developments in cybersecurity regulation at the state level has been the passage of the New York SHIELD Act. On March 21, 2020, New York's Stop Hacks and Improve Electronic Data Security Act, or SHIELD Act, went into effect. The SHIELD Act amended New York's data breach notification law to require covered entities to implement, quote, reasonable safeguards to protect the private information of New York residents. The SHIELD Act also expands the definition of private information to include biometric data, as well as usernames, email addresses, or account numbers with their accompanying password or security question responses, granting access to the account. Now, unlike prior laws or regulations that simply required reasonable security without providing specific expectations, the SHIELD Act outlines the particular aspects of a reasonable data security program that companies are generally required to implement. Such a program will include processes to identify reasonably foreseeable internal and external risks, institute employee training, select service providers capable of maintaining appropriate cybersecurity safeguards, requiring those safeguards by contract, conduct risk assessments to test security measures in place to control identified risks, dispose of personal information after it is no longer needed for business purposes, and adjust the security program as needed. Alternatively, an entity can demonstrate compliance if it is subject to and has met the security requirements under the Gramm-Leach-Bliley Act, the Health Insurance Portability and Accountability Act, or any other federal or New York data security rules, statutes, or regulations. Notably, the SHIELD Act did not create a private right of action for violations of the reasonable data security requirement. Only the Attorney General is empowered to bring an action for injunctive relief and civil penalties for violations of the security requirements. And while New York has yet to announce any enforcement actions specifically under the SHIELD Act, the New York Attorney General has launched investigations into companies' privacy and security practices under pre-existing privacy laws. For instance, in May 2020, Zoom Video Communications reached an agreement concluding an investigation arising from media reports about its privacy and data security practices, many of which have been the subject of substantial attention since the onset of the COVID-19 crisis. Under the agreement, Zoom is required to implement a comprehensive written information security program, enhance its encryption protocols, and perform annual penetration testing. Now, New York is not the first state to prescribe an information security program. In fact, Massachusetts led the effort to require such programs, and for the past 10 years, its regulation has required entities that own or license Massachusetts residents' data to maintain a written information security program. This program document, or WISP, must contain administrative, technical, and physical safeguards tailored to the entity's business and the nature of the data held. Many of the aspects of a reasonable program set forth in the SHIELD Act mirror the requirements articulated in Massachusetts' regulation. For example, Both require an entity to designate one or more employees to be responsible for the program, provide employee training, select service providers that maintain appropriate safeguards and require those safeguards by contract, and routinely evaluate and adjust security measures as needed. In this context, we would be remiss if we did not also mention the New York Department of Financial Services Comprehensive Cybersecurity Standards. Now, these represented one of the first instances after Massachusetts of a state issuing comprehensive guidance prescribing specific expectations for cybersecurity processes and procedures. Now, this regulation applies to all institutions authorized by NY DFS to operate in New York, including many banks, insurance companies, licensed lenders, mortgage lenders and servicers, money transmitters, and insurance professionals doing business in New York, known collectively as covered entities. Now, as of August 28, 2017, these regulations required covered entities to adopt policies and controls to protect consumers' private data and to appoint a Chief Information Security Officer to implement and oversee those controls. Notably, covered entities are required to provide notice to NY DFS within 72 hours of becoming aware of any cybersecurity event, with a reasonable likelihood of materially harming any material part of the normal operations of the covered entity, or for which notice must be provided to any government body, self-regulatory agency, or other supervisory body. NYDFS created a portal on its website for covered entities to file the required cybersecurity event notice. It is worth highlighting that this breach notification requirement is broader than what is required under traditional data breach notification laws. For example, this law could require disclosure of breaches involving confidential or sensitive business information that would not otherwise trigger a breach notice requirement. And although not applicable to all companies, these regulations have and continue to prove prescient as other states consider both targeted and generalized security regulations to which a growing swath of companies may well be subject in the near future. Now, on April 13th of this year, NYDFS issued guidance to Department of Financial Services regulated entities regarding cybersecurity awareness during COVID-19 pandemic. This guidance identified several areas of heightened cybersecurity risk stemming from the pandemic. These included remote working, increased phishing and fraud, and third-party risks. Now, just to dig into this a bit, in discussing remote working risks, NYDFS highlighted the importance of secure connections, the need to secure company-issued devices, including through the adoption of endpoint detection and response and mobile device management, the expansion of bring-your-own-device policies and the need for associated compensating controls, the need to use proper configurations for remote communications tools like video conferencing solutions, and the value of thinking actively about data loss prevention. With that, I'm going to turn it over to Marcus to bring us home and discuss a host of other requirements under state law.
Thanks, Josh. A growing number of states have followed Massachusetts' lead by enacting laws that require companies to maintain a certain level of security. In fact, more than a dozen states, including Texas, Delaware, and Florida, among others, require entities that own or license certain personal information to implement and maintain reasonable procedures or practices to safeguard such data. A subset of states require safeguards, but only for certain types of entities. Connecticut, for example, limits the requirement to healthcare businesses and entities that receive confidential information as part of a contract with the state. Maine has enacted a law that specifically applies to Internet service providers, otherwise known as ISPs. The statute requires ISPs to take reasonable measures to protect customers' personal information from unauthorized use, disclosure, sale, or access. Unlike New York, and Massachusetts. These states do not elaborate on what constitutes reasonable steps. The vagueness surrounding the definition of reasonableness of the required measures could provide companies with some flexibility in their approach to implementing such information security programs. However, it is worth noting that the definition of reasonableness can vary over time and among organizations. So it is important to understand what your relevant state regulators deem to be reasonable. States have expanded the notion of reasonable security beyond personal information. In particular, they have begun to establish laws specifically regulating the security of connected devices. In September of 2018, California became the first state to pass a law on Internet of Things devices. Oregon followed California's lead by enacting a similar law in 2019. Both laws went into effect on January 1st of 2020. These laws require manufacturers of devices or other objects capable of connecting to the Internet and being assigned an Internet protocol or Bluetooth address to equip these devices with reasonable security features. For example, the laws address the use of generic default device passwords, which is a common problem with devices sold to consumers. Both laws specify that for devices authenticated outside of a local area network or LAN, reasonable security features include a unique pre-programmed password and the requirement to prompt users to create a new password before using the device for the first time. Beyond specifics about passwords, the laws provide limited guidance on what constitutes a reasonable security feature. Instead, they both broadly define reasonable security features as those that are appropriate to the nature and function of the device, appropriate to the information it may collect, store, or transmit, and designed to protect the device and any information contained therein from unauthorized access, destruction, use, modification, or disclosure. Neither state has issued additional guidance to clarify how reasonableness will be evaluated. Although these could be substantial requirements, both laws offer several exemptions. For instance, the laws do not apply to devices otherwise subject to the security requirements of HIPAA or the U.S. Food and Drug Administration regulations. These provisions could theoretically exempt manufacturers of medical devices, although there is currently uncertainty regarding this key question. Also, California's law provides an additional exemption not included under the Oregon law for devices whose functionality is subject to security requirements under other federal laws, regulations, or guidance promulgated by any federal agency. The Oregon law provides that a reasonable security feature may consist of compliance with requirements of federal law or federal regulations that apply to security measures for connected devices. Though neither state's law establishes a private right of action, each state's attorney general may initiate an enforcement action under the state's law. How these states will interpret and enforce these new laws remains to be seen. As of November the 1st of 2018, Ohio became the first state to incentivize businesses to implement a cybersecurity program by providing a safe harbor to businesses that do so. A company may assert a safe harbor defense against any tort claims that allege a failure to implement reasonable data security controls in the event of a data breach, if that company has implemented a written cybersecurity program that does the following: has a design that protects the security and confidentiality of the information, protects against anticipated threats or hazards to security or integrity, and protects against unauthorized access to and acquisition of the information that is likely to result in a material risk of identity theft or other fraud, and reasonably conforms to certain governmental or industry cybersecurity frameworks or laws for the protection of personal information. Unlike other states' laws, the Ohio law is voluntary. It gives businesses a reason to be proactive with their cybersecurity programs instead of introducing additional regulations required for them to follow. This regulation, this law, is not meant to be a minimum cybersecurity standard. The development and use of contact tracing, proximity tracing, and exposure notification applications to combat the COVID-19 pandemic have led to increased privacy concerns about the collection, use, and disclosure of extensive personal, medical, and geolocation data. Members of the U.S. Senate have drafted 3 federal privacy bills in recent weeks intended to build public trust in the use of personal data to address the current pandemic. The most recent bill is the Exposure Notification Privacy Act, a bipartisan bill introduced on June 1st of 2020 by Senators Maria Cantwell, Bill Cassidy, and Amy Klobuchar. ENPA is unique in that it applies to any infectious disease and would not expire once the COVID-19 public health emergency ends. ENPA establishes privacy requirements for operators of infectious disease exposure notification services. 2 other prominent Senate bills also have emerged. On May 7th, a group of Republican senators, led by Senator Roger Wicker, introduced the COVID-19 Consumer Data Protection Act of 2020, or the CCPA. On May 14th, a group of Democratic senators, led by Richard Blumenthal, introduced the Public Health Emergency Privacy Act, or PHEPA. The 2 competing bills contain many similarities, including requirements for obtaining affirmative express consent for collecting and processing COVID-19 information, recurring data deletion, and data minimization. That said, these bills do have notable differences. For example, the Democratic bill includes a private right of action, while the Republican bill does not. It limits enforcement to the FTC and state attorneys general. In addition, while the Democratic bill contains a section expressly declining to preempt state laws, the Republican bill contains an opposite section expressly preempting state laws related to the collection, processing, or transferring of covered data. None of these measures has moved meaningfully toward passage, but as the U.S. continues on the path to reopening, these bills and similar measures will continue to be discussed, with some seeing them as a vital element that is necessary to a secure and privacy-respecting reopening. When planning for the road ahead, there are many uncertainties for all of us. We face questions about navigating COVID-19, and there are questions about the laws that states will pass, as well as how regulators will implement them. If you have questions for us, as noted earlier, please use the question and answer widget on the left-hand side of your screen, and we will follow up with you individually. I thank Lay and Josh for presenting with me today, and we thank you for joining us. Please be well and stay safe.